10 seconds. Huh? Turn the music down. Now you see what I'm talking about now. I think this thing is blocking the view. Hello, hello. Welcome to Dr. Olu Asekun's live podcast. This podcast is going to be every Wednesday, 12 p.m. Central Standard Time. That is Dallas time. So today we'll be discussing employment-based green card. Employment-based green cards. Welcome. You are welcome. Please join us every Wednesday, 12 p.m. Central Standard Time. Invite your friends and family. This is free of charge. There is no need to pay consultation fee. Here we'll be answering all immigration questions. But today, we'll be answering questions relating to employment-based immigrant visas, employment-based green cards. So you are welcome. This is Dr. Olu Asekun again. Every Wednesday, please join us for a live podcast, for an opportunity to answer all your immigration questions. Today, we'll be discussing employment-based immigrant visas, employment-based green cards. So, send in your questions. You can call us on 817 493 983 4499. Let me get the number correctly. 817 983 4499. You can also send in your question through this chat. You can send in your question to us on WhatsApp. You can send your question on WhatsApp, 817 983 4499. You can reach us on WhatsApp. You can reach us on phone call. You can also reach us by chat, live. So you are welcome to today's podcast. Today, we'll be discussing employment-based immigrant visas. So please send in your questions. We are waiting for your questions. In the meantime, while waiting for questions, I'm going to give an overview of employment-based immigrant visa. Employment-based green card, you can actually get green card through employment-based. They are divided into 5 categories. 5 categories. EB1, EB2, EB3, EB4, and EB5. So when we say EB1, the word EB naturally means employment-based. So when we say EB1, we are talking about employment-based first category. Employment-based first category. That's what we are talking about when we say EB. So the first category, EB1. So what that means is we are talking about aliens of extraordinary ability. Aliens of extraordinary ability. Now, when we say alien under U.S. immigration law, it simply means foreigner. It simply means foreigner, nothing more than that. So when we say aliens of extraordinary ability, so what we are saying in essence is foreigners with extraordinary talent. foreigners with extraordinary talent. So that's what that simply means. So there are two categories of aliens of extraordinary ability. That is EB1. There are two categories. One category is EB1A. That will be aliens in management position in a multinational company. Aliens in management position in a multinational company. So in other words, if you are in a management position in a multinational company with a company with a branch here in the US, and you are in management position, you may be able to apply for green card with your status. Let me give you an example. Let's say there is Mobile, South Africa. This is just an example. Let's say there is Mobile, South Africa, and there is also Mobile, US. Now, if you are a general manager in Mobile, South Africa, that is a management position. So if you want to relocate to the US, if Mobile, South Africa transfer you to US, you can apply for green card as alien in a management position in a multinational company. So in other words, you can apply directly for green card under EB1, EB1A. Now, the B part of EB1A, that is the aliens with extraordinary ability. So what that means is that in your profession, you must be someone who has achieved the highest standard in your profession. Maybe you have won international awards. Maybe you have produced research that has earned international awards. Maybe you have invented something that is of international value. Maybe you are so notorious in your field that you are recognized worldwide as an expert in your field, as someone the members of your profession rely on. Maybe you have won the Nobel Laureate Prize, or maybe is it something Pulitzer Prize? You have won some international awards. So, I mean, it's something that shows your talent, your extraordinary skill in your profession. So if you have any of those things, it is self-petition. You don't need any employer to sponsor you. You can apply on your own based on your skill and your accomplishment. That is EB1. Now, the next one will be EB2. EB2. EB2 is also divided into two. The first one is alien of exceptional ability. Remember, EB1 is extraordinary ability. This one is exceptional ability. They are not the same. The requirements are different. They are not the same. So it's very important that we understand it. Please, can you move this? It's blocking the view here, I think. Can you see? No, maybe this way. I want to be able to see myself. Thank you. I think it's better. Yeah, I think it's better. Okay, going back to EB2. As I was saying, EB2 is different from EB1. EB1 is alien of extraordinary ability. And this one, EB2, is alien of exceptional ability. Now, the difference between extraordinary ability and exceptional ability for EB2. For EB2, it is called national interest waiver. You are telling the US government to waive the requirement of what we call labor certification. So you are telling them to waive the requirement of labor certification. So that is what EB2 is all about. It also means that you must have some exceptional talent. You must have some skills that an average American citizen having the same qualification as you does not have. You must have some form of skills that when compared with an average American who have the same qualification as you will be on a higher pedestal. So those are the things that you have to show in getting EB2 approved. But the national interest waiver aspect of it, I'm going to explain what is called labor certification, because when you understand what is called labor certification, then you'll be able to understand the requirement of national interest waiver. Now, labor certification simply means that before an American employer can hire a foreigner, they are required by law to offer the position to American citizens first before they can consider foreigners. Now, the employer will be required to place advertisement. Whenever an employer has an opening, whenever they have a job opening, they will be required to place advertisement in a major newspaper in the area of intended employment. They will be required to place advertisement with the state workforce agency. The employer will be required to place advertisement, at least 3 different advertisements in 3 online job search websites where American citizens go to apply for jobs. The employer will be required to place advertisement in the employer's website. In addition, the employer will be required to place what is called notice of job offer and place it in the employer's principal place of business. The employer will be required to carry out some additional recruitment steps. Now, after doing all of this, if there are no Americans who apply or there are no Americans who are interested in the job, then the employer will submit an application for labor certification to the Department of Labor. Now, in submitting this application, the employer will include all the advertisements that were placed, all the recruitment steps that were placed concerning this particular position, and show that after all of this effort, there are no American citizens who are eligible or who are interested. Americans may be eligible, but they may not be interested in the job. But the employer will have to submit that application to the Department of Labor. Now, after submitting the application, the Department of Labor can do one of 3 things. The Department of Labor can either approve the application, they can either deny the application, but they can also go ahead and audit the employer. They can audit the employer. What that means is that they can question the employer's recruitment steps. They can ask the employer, okay, when you place this advertisement in a major newspaper, how many people applied? What is the reason why you believe they are not qualified? Did you even interview them? How did you contact them? If you send them a mail, we want to see a proof. If you mail them a letter, we want to see proof of delivery. If you call them over the phone, we want to see your phone record. So they can raise a lot of questions to kind of audit the employer. And if at the end of the audit, if they find out that the employer was trying to play smart, or that the employer was the recruitment, the advertisement was made in a way to favor a particular candidate, the employer could be sanctioned. The employer could be penalized. There are lots and lots of things that the employer could do, the Department of Labor could do to the employer. But if at the end of the day, if after all the audit, if the Department of Labor is satisfied that the employer has complied with all the necessary requirements, then the Department of Labor can approve that labor certification. It is only after that that an employer can actually commence the immigration process. It is only after that that an employer can submit an immigrant petition on behalf of the potential foreigner. Now, called labor certification is very important because this is what explains the difference between national interest waiver and EB3, which requires an employer to sponsor a candidate. Now, when you apply for national interest waiver, EB2 national interest waiver, you are telling the US government to waive this process called labor certification. As I've explained it, this labor certification process is a process that was put in place to protect American citizens, to protect American jobs. So the question is, what is so important about you that will warrant the American government to waive a process that was put in place to protect American citizens? What value are you bringing to the table that is so important and unique to the extent that it will outweigh the need to protect American citizens? What contribution are you making that is so valuable to the extent that a process that was put in place to protect Americans will have to be waived for you? That is why it is called national interest waiver. You are saying that your skill is so important that it will be in the interest of the American government to waive that labor certification requirement for you because of the uniqueness, because of your talent, because of your skills. So that is the requirement for EB2, national interest waiver. Now, as I said at the beginning, even EB2 is divided into two. So the one I've explained so far is the national interest waiver portion of it. The B part of EB2, that one requires every applicant to have a minimum of a master's degree. In other words, if you have only a bachelor's degree, you are not eligible for EB2 employer sponsored. So you are required to have a minimum of master's degree, and then you need an employer who will petition for you, who will sponsor you, and of course the employer will need to go through the labor certification process in order to petition for you under EB2 under EB2 with an employer sponsored petition. Now, the next employment-based category is EB3. Talking about EB3, that is skilled workers. Skilled workers. I usually refer to this as a bottom of the pyramid. EB3, that only requires you to be a skilled worker. In other words, if you have a bachelor's degree, if you have an employer willing to sponsor you, you can apply for green card under EB3. You can also apply for green card under EB3 even without having a bachelor's degree, for as long as you are a skilled worker. For example, nursing, you only need an associate degree to become an RN. If you are an RN, you can apply for green card under EB3. The only difference is that you need an employer to petition for you. And of course, for nurses, that's very easy. There are employers who may be able to petition for you if you are licensed in any part of the United States as a registered nurse. Now, the next one is EB4. EB4 is special immigrants. Special immigrants. Those are special immigrants. If you are a special immigrant, let's say you are a pastor, you are a minister, and you have been working for the U.S. employer for at least 2 years immediately preceding the filing of the petition, the U.S. religious organization can petition for you, can file an immigrant petition for you under EB4. So they will have to file Form I-360 on your behalf under EB4 category. In addition, if you are working, if you have worked with a U.S. embassy anywhere in the world, and you have worked for not less than 10 years, and you retire voluntarily, not that you are fired. So if you want to live in the U.S., yes, you can apply for green card under EB4. The last but not the least is EB5. EB5, you can apply as an investor. You can apply for EB5 as an investor. You can either apply as an investor under regional center program, in which case you will be required to invest $800,000. You can also apply as an investor on your own, in which case you don't need to go through any regional center. But in such a situation, you'll be required to invest minimum of $900,000. Well, in addition, whether you go through a regional center or you want to do it yourself, there are additional expenses associated with the investment in order to get a EB5 petition approved. Of course, you will need attorney's fee, you will need filing fees. If you go through a regional center, you will need administrative fee, usually charged by all regional centers. So these are the 5 categories of EB5. Now, let the questions start rolling in. Let the questions start rolling in. We'll be willing to answer all of your questions. Send in questions. When you have specific questions, it is easier to direct response to the questions rather than talking generally. So let the questions start rolling in. Let the questions start rolling in. Our lines are open. 817-983-4499. You can send in your question through to ask your questions. 817. I think the questions are beginning to come in. Let me see. I think it's better for me to read the questions on the phone. Okay. Yes, questions are beginning to come in. Well, if I do premium processing on a national interest waiver, will I get my green card faster? Well, this is a good question, but the question depends on a lot of other factors. The first question is, it depends on where the applicant is applying from. If you are applying from the United States, the procedure is different from when you are applying from outside the United States. And let me say this. When you apply for green card based on employment or even based on anything at all, the processes are different. When you apply under employment based, is a 2-step process. The first process is the immigrant petition. Immigrant petition, that is the first process. So when you apply for national interest waiver, when you apply for immigrant petition under national interest waiver, you are doing a self-petition. So that petition is not the same thing as green card. It is petition. So you have petition for immigrant worker. That is the petition. So when we are talking about national interest waiver, we are talking about the petition. Petition for immigrant worker. So we are talking about the petition. That is completely different from green card. If you are in the United States, you can apply for green card concurrently with the petition. Now, the petition, there is provision for premium processing for the petition, but they are not the same. So when you apply for immigrant petition for alien worker, you are only applying for the national interest waiver portion of the process. So you are applying for green card on the basis that you have an immigrant visa either pending or approved on your behalf. So that is the basis of your green card application. That is not the green card application itself. So to answer the question, national interest waiver, EB2, national interest waiver, there is premium processing for it. Yes, premium processing means that if you pay the additional filing fee, additional processing fee, your petition will be adjudicated within 15 calendar days. Yes, that is speed. It is possible. Your petition could be approved within 15 calendar days, which is about 2 weeks. But that is good. But that is not the same thing as green card, because the green card application itself, that is the I-485, and there is no provision for premium processing for I-485. So you may have your petition approved while your green card application is still pending. But to be honest with you, is there an advantage? Yes, because once your petition is approved, once your petition is approved, that is the main thing. Because if the petition is denied, you cannot get green card. The green card application is going to be automatically denied. But if the petition is approved, the green card application is likely going to be approved. No matter how long it takes, it's going to be approved, except you committed a crime or you are disqualified on other grounds, maybe on health ground, because everyone who is physically present in the United States and is applying for green card is required to go through medical examination. Even when you apply from outside the United States, you are required to go. An applicant can still be disqualified on health ground. So, except any of those happen, once the petition is approved, it is almost whether you stand a chance of getting the green card. Why not? Yes, you can go through the process of premium processing. But to be honest with you, if you ask me my opinion, because EB2, national interest waiver, because the truth of the matter is that concurrent filing will allow you to obtain employment authorization. Concurrent filing will enable you to obtain travel document. So once you have employment authorization and you have travel document, just wait for them to take their time. Whenever it is approved, you know that you get your green card. But if you are not sure whether your petition will be approved and you want to make that determination as quickly as possible in order to determine your next option, then I will advise you to go for premium processing so that you know your fate, whether the I-140 petition will be approved or otherwise. So I believe I've been able to explain that. Now, we have some other questions. This question was sent in through our WhatsApp. I have just been granted my LPR based on approved I-360 religious worker petition. My child, 13 years old, is back in Nigeria. Can he join me in the US and how? This is very simple. Yes, your child can join you. Yes, your child can join you. As to how, that one I will advise you to seek experienced immigration attorney, to seek advice from an experienced immigration attorney, because it's a complicated process, and if you get it wrong, it may affect other things. So, but to answer your question, is it possible? Yes, it is possible. The process is what we call follow to join. The process is called follow to join. So once you have been granted your LPR status, you commence a process that is known as follow to join. For as long as your child is still under 21, your child will be eligible. But like I said, I will advise you to seek counsel from an experienced immigration attorney, because if you miss the process, you may have to petition for your child. You may have to go through family-based petition, which means a permanent resident petitioning for a child or married child under 21. But again, with your LPR status, you can get your child to join you also as a permanent resident. So the process is called follow to join. But again, my advice, it is better that you seek advice from an experienced immigration attorney who understand the follow to join process. But to answer your question, yes, it is possible. So keep the questions coming. Keep the questions coming. Keep the questions coming. I can see someone is typing. Keep the questions coming. Keep the questions coming. This process will be repeating it every Wednesday by God's grace, 12 p.m. Central Standard Time. That is 12 p.m. Dallas time. Here we will be answering all your immigration questions. There is no string attached. No consultation is required, no strings attached. The entire purpose is just to provide information to people, because of our experience that we see people make avoidable mistakes, avoidable errors. We see it day in, day out, and it has been our intention to provide information to people so that you avoid simple errors. Simple errors. So keep the questions coming. Keep the questions coming. Okay, we have another question from our WhatsApp number. Keep sending your questions. Our WhatsApp number is 817-983-4499. 817-983-4499. So sending your question, the more questions I'm able to answer, the better for the listeners. So keep sending your question. Okay, the question I have multiple children ranging in ages between 9 to 23. Will they be eligible for the immigrant visa, or is the 23-year-old too old to be included in the petition? Well, I don't know. Is this the same person that sent the question about the I-360? Okay, so this is a follow-up from the follow to join will only be possible if your children are under 21 at the time you obtain your permanent residence. Your children must be under 21 at the time you obtain your permanent residence in order for them to be able to join you through the follow to join procedure. Yes, they have to be under 21. Anyone who is over 21, your child will be eligible for CS. Listen to the podcast on Child Status Protection Act, and then you can follow to join process. If they turn 21 while the process is ongoing, they may be eligible for protection under Child Status Protection Act. But again, there are still some other requirements. So that is why it is not easy for me to tell you specifically whether your children will be eligible or not, because there are still some other requirements. For example, at the time you commence the follow to join process, is visa available for that category? Those are the things that will determine your child's eligibility. But generally, those who are over 21 will not be eligible. Those who are under 21 will be eligible. So if you need additional clarification on that, it is better to consult an experienced immigration attorney who may be able to look into your specific circumstances and then determine whether your child can still be can still benefit from Child Status Protection Act. Text, okay, I have an approved religious-based I-360. My I-485 application is pending. I have a work authorization. Can I leave the church that petitioned for me for a new job? This is a brilliant question. This is a very good question. This is the kind of questions that we see all the time, the kind of scenario that we see all the time. And I can tell you, this is one of the reasons for this podcast, to give out information so that people don't make what we call avoidable errors, avoidable mistakes. Now, before I answer this question, I want to remind our viewers again, we do this program every Wednesday, 12 p.m. Central Standard Time. Every Wednesday, 12 p.m. Central Standard Time. It is free of charge. There is no consultation fee. There is no strings attached. It is purely to provide information to our people. Please log in, tell your people, tell your friends, tell family, subscribe to our channel so that when we go live, you will be notified. Thank you. Now back to the question. I have an approved religious-based I-360. My I-485 application is pending. Capital no for the previous employer. However, in the case of religious worker, the requirements are completely different. The statute, that is Immigration and Nationality Act, the statute used the word solely, S-O-L-E-L-Y, solely, S-O-L-E-L-Y. The statute used that word. So what that word means is that solely, only you, until you get your green card. Yes, when you get your green card, you can work for another employer. But while your green card is still pending, if immigration finds out at any stage before the green card is approved, I guarantee you the green card is going to be denied. So I hope I've been able to explain answer this question extensively. So, but if you still have doubt, you can request clarification, or if there's anything you don't understand, you can request clarification. Okay, we have another question. My religious-based I-360 was approved, and my 485 is currently pending. Can I stop working for my employer and get a new job? Yeah, I think this is what I just answered now. Okay, I think multiple people have the same question. It's interesting. Multiple people have the same question. This is the same question I just answered. The answer is no. You cannot stop working for the employer until you get your green card. If you stop working for the employer at any time and immigration finds out, then they are probably going to deny your green card application. So you cannot work for any other employer. Again, for those who are just joining, or those who have been going on and off, I don't want you to misunderstand my explanation here. If your employer is not religious based, you can change employer, you can change employment after your application has been pending for 180 days. But we are talking about religious-based petition here. Petition filed by a religious organization. You cannot change employment. You cannot change your employer until after the green card is approved. So that is the distinction. That is the difference. Okay, so another question. Why does the visa bulletin retrogress? And if it says a visa is available, does that mean my visa is approved? Well, good question. Good question. Let me answer the B part first. Please keep the questions coming in. This is interesting. Keep the questions coming in. It's an opportunity for me to be able to answer all of them. Keep the questions coming. Yes. If it says a visa is available, does that mean my visa is approved? No, no, sir, no, ma. I don't know if this is a man or a woman, but the answer is no. That is not what it means. Now, why does the visa bulletin retrogress? Let me explain that. You see, every single employment-based visa application, every single employment-based green card, they have limited number of green cards that immigration can approve per year. Either EB1, EB2, EB3, EB4, or even EB5 investors. Every single category have limited number of applications that immigration can approve. Now, once they hit the limit, that is when visa retrogress. So, if, for example, this is just an example. If, for example, let's say EB1, if immigration is allowed by law to approve only 10,000 per year, and let's say immigration received 100,000 applications for that category, they can only approve 10,000 by law. So that means the entire 90,000 remaining will be on the queue. They will be in the backlog. So let's say the following year, immigration received another 100,000 applications. They will not even touch it. They will go back and take 10,000 from the previous year. Remember, they have 90,000 backlog from the previous year. So they will just go back there and take the 10,000. So the new 100,000 will just join the queue. They will not join it. That is what backlog is. Now, what determines whether visa becomes available or it retrogresses or it progresses depends on a number of factors. One, while some of those 90,000, the example of 90,000 that I use, while they are on the queue, some of them may get green card through other means. Let's say somebody with a pending application under EB1 or EB2 or EB3, EB4 or even EB5. Maybe the person has an opportunity to get green card through another means. For example, let's say the person was single at the time he applied. Now, the person is now married to a United States citizen. Now, that person will have the opportunity to now apply for green card under family-based as opposed to employment-based. Now, under family-based too, we have visa availability issues, but immediate family does not. So if you are married to a United States citizen, you become immediate family of that US citizen, and that takes you out of this visa waiting period. It takes you completely out. So at the end of the day, maybe out of the 90,000 from the example that I use, out of the 90,000 applicants that are pending, maybe another 5,000 got green card through other means. So that will reduce the backlog. Again, other factors that can also determine whether visa becomes available or is not available. From month to month, the number of applications that immigration received may vary from month to month, even from year to year. Example, going back to the same example that I used, maybe in 2020, maybe immigration received 100,000 applications. They were able to process only 10,000. They have 90,000 backlog. Maybe in 2021, they receive only 20,000. Now, the backlog is not going to be as much as if they had received another 100,000. So a lot of factors affect this thing, and that is why it is difficult, even for immigration themselves, to predict when visa will be available and when they will not. But this assignment is given by statute to the Department of State. So it is the Department of State that releases monthly visa bulletin to let us know where we are on the queue. So I believe I've been able to answer that question. And again, when visa is the B part of the question, if it says visa is available, does that mean my visa is approved? No, it means that you can now apply for green card. That is what it means. And if your green card application has already been pending, it means that immigration can now adjudicate your application. That is what it means. It doesn't mean it is approved. It means it is now time to either adjudicate a pending petition or for you to submit an application. Beneficiary of an immigrant petition, but I'm on F1 attending school. Can I also apply for green card with my husband if I'm in a different status? Yes, if the answer is yes, if your husband is the beneficiary of an immigrant petition, so what I'm getting here is that only the petition is pending. So apparently, the adjustment application was not filed concurrently with this petition. But even if it was filed concurrently, for as long as it has not been approved and you are married to him, yes, you can apply whenever visa becomes available for him. Both of you can apply for green card and both of you will get it. If his application is already pending, all you need to do is to submit your own application, attach a copy of your marriage certificate to show your relationship, and your application will be merged with his own, and you will be able to also get adjudication at the same time. So the answer is yes, you can get it. It doesn't matter what status you are, but you must be in legal status at the time that you apply for adjustment because it's employment based. Okay, another question. Please keep the questions coming. I'm encouraged. Please keep the questions coming. The next question. How do criminal charges affect my employment-based green card application? My case is still pending at the criminal court. Well, this is a good question, but the question is not very clear because I will need a follow-up, because when you are talking about criminal charges, there are different types of criminal charges. Every single application for permanent resident, whether it is employment-based, whether it is family-based, whether it is one of those special immigrants, every single application for permanent resident, every single application for green card will be affected by criminal charges, every single one of them. But now, whether you get the green card or not depends on the nature of the crime and also depends on the conviction. You cannot be denied a green card based on charges. You can only be denied based on conviction. So it depends on what you are convicted of. If the charges is thrown away, if the charges is dismissed, definitely it's not going to affect anything. But if you are convicted, it now depends on what you are convicted of. Some convictions definitely will prevent you from getting the green card. But with some convictions, you may be able to still get the green card. And of course, with some other convictions, depending on your peculiar situation, you may be able to apply for a waiver of criminal grounds of inadmissibility. Again, the immigration is not a one-cap-fits-all. It's not something I can tell you a yes or no. One, the criminal case will have to be completed, and we will have to see whether you are convicted or not. Two, even if you are convicted, we will have to see what the conviction, uh, what you are convicted of, in order to determine how your case could be best resolved. But I will advise you, if you are not a US citizen, you are still processing your green card, and you have criminal charges against you, I will I will seriously advise you to get your criminal defense lawyer to work with a very good immigration attorney, so that you don't go into some plea bargain that will destroy your path to becoming a permanent resident. Very, very important. So that would be my advice in this case. Now, another question sent in through our WhatsApp. You mentioned that EB green card applicant must keep current status. So even if my husband is in status and I'm not, will my own application be denied? Yes, the answer is yes. Everyone applying for green card through employment must be in legal status at the time that the green card application was filed. That is a mandatory requirement of the law. So it is not the same for family based. For family based, you may be out of status and still get your green card. But for employment based, you must be in status at all times. Even though there are one or two exceptions, if you have been out of status for only a very short period of time, maybe less than 180 days, you may be able to still get your green card. But if you have been out of status for 180 days or more, the application will be denied. You have to be in legal status. It doesn't matter whether you are the principal applicant or your husband is the principal applicant. Both of you must be maintaining legal status. Please keep the questions coming. Okay, another one just came in. My friend's immigrant petition has been approved, but his adjustment application has been pending since 2005. What can he do to get a decision from immigration? 2005, if I calculate correctly, that's almost 17 years ago. There must be more to it that you are not telling us. Maybe you need to ask your friend more information. For example, I will need to know what category, under what category did he apply. I will need to know what country is he from. So we need to determine visa availability. Again, for some countries with large immigrant population coming into the United States, the visa availability is different. It is not a one-cap-fits-all. So for example, I do know that, especially when it comes to employment-based, applicants from India, they have a longer waiting period than generally other applicants from Europe or Africa, for example. So we have to know what country your friend is from, and we also need to know under which category was he applying for green card. So was he applying under EB1, EB2, EB3, EB4, or EB5, and from what country? Because 2005 is a long time. So we need to know all these things before we can advise you. But I can tell you, if your friend is from a country where visa has been current for some time now, then I don't also know whether this is a self-petition or this is a employer-sponsored petition. So there are so many unknowns. I would like it if you can just clarify this. Okay, let's see. It was Nigeria and religious based. Well, If it is if your friend is from Nigeria and this is religious based, I-360, again, there are a lot of factors that could affect it. For religious based petition from Nigeria, this is not common. It is not impossible, but it is not common. But you see, this is where this is one of the reasons why I keep saying that immigration is not a one cap fits all. You may need to tell your friend to consult with an experienced immigration attorney. But let me tell you this. If this is a religious petition, visa has been current forever. Visa is still current even as I speak now for religious petition. It has been current forever. However, every case is different. Every situation is different. If you have, there's a saying that he who lives in a glass house does not throw stone. There are some steps you can take against immigration that can backfire if your house is not in order. In other words, the first question you need to ask your friend, is your friend actually working for the employer? Is your friend actually working for the petitioning religious organization? So those are some of the things you need to find out, because yes, there are steps that you can take depending on the peculiar situation of the case. If this person were to be my client, there are steps that I can take with guarantee that immigration will adjudicate this case within, at the maximum, within 90 days. But the question is, can you take such a step without knowing the actual situation on ground? For example, is the employer paying the beneficiary? Is the beneficiary doing what they told immigration that they were going to do? There are a lot of unanswered questions. So I keep saying immigration is not a one cap fits all. So I'm not going to sit down here and just tell you this is what you should do. I would rather tell you, consult with an experienced immigration attorney. Let them look at the specific peculiarity of your situation and then advise you appropriately. That would be my advice in this case. But this is unusual. We see it once in a while, but I can tell you it is probably maybe 1 in 10,000. Maybe 1 in 100,000. It's very unusual. Even maybe 1 in 1 million. Extremely unusual. But it does happen. We have seen it before. So keep the questions coming. Keep the questions coming. I mean, for the first time since we started this podcast, we have been doing this uninterrupted. We have not had a break. We have not had a short break or anything. Keep the questions coming. It is encouraging. I'm willing to continue answering the questions. Keep them coming. Keep them coming. That is the exact purpose of this, to be able to provide information. There is no strings attached, no consultation fee required. We will answer all your questions. Keep them coming. Let your family and friends know we are still live. We'll probably be live for about another hour. Keep the questions coming. No strings attached, no consultation. All you need to do is just to subscribe to our channel so that you receive notification every week once we are live. This is going to be, by God's grace, every Wednesday, 12 p.m. Central Standard Time. Every Wednesday, 12 p.m. Central Standard Time. Today we are discussing employment-based immigrant petition, employment-based green cards. So if you have questions relating to employment-based green cards, send them in. Questions about EB1, questions about EB2, National Interest Waiver, questions about EB3, Skilled Worker Program, questions about EB4, special immigrants, questions about EB5, immigrant investors. Send your questions in. Keep the questions coming. We have not had a break, and if the questions keep coming, I am willing to keep going without a break. Send in the questions. Keep them coming in. Keep the questions coming. I can see that someone is typing. Keep the questions coming in. Keep the questions coming. Keep them coming. This is going to be every Wednesday by God's grace. Every Wednesday, 12 p.m. That is Central Standard Time. Dallas time. We are located in Dallas, in Arlington, Texas. So 12 p.m. Dallas time. Keep the questions coming. You can call in 817-983-4499. You can send in your question through our WhatsApp. Our number is 817-983-4499. You can also send in your questions directly. You can type it on our chat. You can also send your question through our WhatsApp number. Okay, another question just came in. This is from our WhatsApp number. Can someone with a work permit keep a part-time job outside of the church that petition for them? Well, I believe that this is a question that I've answered, but I will repeat it. As I said before, religious petitions are completely different from other employment-based petition. Someone may be wondering, why is religious petition treated differently? The answer is very simple. When I was explaining EB2, National Interest Waiver, I explained a process called labor certification. Labor certification, which requires an employer to first offer the position to American citizens first before they can offer it to any foreigner. Labor certification process, which requires the employer to place advertisement in a major newspaper in the area of intended employment. Labor certification, which requires the employer to place advertisement in at least 3 online job search websites where people go to look for job. Labor certification process, which requires the employer to place the opening position in the employer's website. Labor certification process, which requires the employer to place notice of job offer in the employer's principal place of business. I explained all this process called labor certification. Now, this labor certification process is waived for 3 professions. This labor certification that I explained over and over and over is waived for 3 professions. The process is waived for nurses. It's waived for nurses. The process is waived for physical therapists, and the process is waived for pastors and ministers. It's waived for religious employees. So, this labor certification process is waived for religious employees. Therefore, immigration is very strict with religious employees. They waive it for nurses and physical therapists because American government made a determination that nurses and physical therapists are in shortage in the United States. So, if nurses are in shortage, it will not make sense to ask an employer to first offer the position to Americans first, when we already know that there are not enough Americans who are available as nurses. So it doesn't make sense to insist that you have to offer the position to Americans first. So that is why they waive it for nurses. The same thing applies to physical therapists. American government already made a determination that there are not enough physical therapists in the United States. So it doesn't make sense to ask employers to offer the position of physical therapist to Americans first when they already know that there are not enough physical therapists in the United States. Now, in the case of religious petition, you will see that religious employees are not in the same category as nurses and physical therapists. But because religion is a sensitive topic, because American government cannot tell somebody what to believe or what not to believe, because it will be difficult for American government to tell a religious organization that they have to employ an American who may not believe the same thing they believe, who may not even understand their religious beliefs. That open for the employer, for the religious organizations to hire anybody of their choice. However, they also monitor it to ensure that those religious organizations does not abuse the privilege. So that is why they use the word solely, Solely, solely. Therefore, let me go back to the question. Can someone work with a work permit? Can someone with a work permit keep a part-time job outside of the church that petition for them? So going back to my explanation, the word solely means that you cannot. You cannot do a part-time. You are required to work for the employer and the employer only, at least until the green card is approved. Once the green card is approved, yes, you can choose to work for anybody of your choice. But until the green card is approved, you cannot. So I believe that I've been able to answer that question. So keep the questions coming. It's interesting. As I said, we will keep going for as long as questions are coming in. This is the first time, the first week ever that we will do this without a break. We've been doing this now for over an hour, and I'm willing to keep going for as long as questions are coming in. That is the whole process. That is the whole purpose of doing this, to answer questions. I'm willing to keep going. Keep the questions coming. For as long as the questions are coming in, I'm willing to keep answering your questions. So keep going. Send the question in. This is a program that will continue to hold by God's grace every Wednesday, 12 p.m. Central Standard Time. That is every Wednesday, Dallas time. So tell your friends, family members, tell them to join us every Wednesday. Subscribe to our YouTube channel so that when we go live, you'll be notified. Send your question in through WhatsApp, through phone call, or even through live chat. Our number is 817-983-4499. Our WhatsApp number, 817-983-4499. Keep the questions coming. I think another question came in. My child's adjustment of status application was denied because USCIS said he was too old and had aged out, but he was under 21. What can be done? I'm sure you are probably... Oh, okay. I think there's a clarification. Okay. Let me read the question again. My child's adjustment of status application was denied because USCIS said he was too old and aged out, but he was, I'm trying to construct, under 21 when the immigrant visa became available. I'm trying to understand this question. My child's adjustment application was denied because USCIS said he was too old and he had aged out, but he was under 21 when immigrant visa became available. Okay. Yeah, I think I got the question. What this person is trying to ask. I believe that this person is trying to ask question relating to Child Status Protection Act. As I said earlier, we did a full program like this on in one of the previous weeks on Child Status Protection Act. So you may want to go back and listen to it on our YouTube channel. However, as I said before, Child Status Protection Act has a lot of requirements. One, the application must have been filed at the time before the child turns 21. Visa must be available before the child turns 21. I'm not saying this is the particular reason for this particular case, but what I want to say here is that it may be that this person did not act within 1 year of visa becoming available, because that is one of the requirements of Child Status Protection Act. So the applicant must act within 1 year of visa becoming available. So that is also an issue. So I really don't know the details of this case, and it is difficult to answer question directly or with peculiarity when you don't have the specific details. But my suggestion would be just go back to our recorded video, our video on Child Status Protection Act. Look at all the requirements. So do a checklist of each one of them. So if you do a checklist of them and you believe that each of your children, your child meets each of the requirement, then I suggest you either contact any experienced immigration attorney or contact our office and we'll help you look more deeply into it. But I tell you, if you meet all the requirements, it will be approved. I can assure you of that. Sometimes immigration or even the Department of State, sometimes they do miscalculate the Child Status Protection Act. So if you believe that it has been miscalculated, there is a way to challenge their decision. But the only challenge here is that you have to act on time. So I don't know if this case has already been denied, and if it has been denied, how long ago has it been denied? So those are some of the things that we need to look at. Those are some of the things that we need to look at. So it's not something I can just tell you whether it is right or wrong. But if you send in more information about it, or if you consult an experienced immigration attorney, I'm sure you'll be able to get more information about that. Now, another question from our WhatsApp: can someone working on CO8 file for EB3? What do you mean by CO8? CO8 is a category for employment authorization. So this question is not clear. If the sender is listening, you can clarify it. Can someone working on CO8 filed for EB3? CO8 is a category under which you apply for employment authorization. So there are so many categories under which one can apply for employment authorization. So CO8 is just one of them. And CO8 is not a status that I can get. So I really don't understand the question. Can someone working on CO8? CO8 simply means a category one of the categories under which one can apply for employment authorization. So please clarify your questions, send in more questions. We are waiting. Keep the questions coming. Keep the questions coming. Like I said, for the first time, this is the first time that we will do this program without a break. We have been on live now for almost 1.5 hours without a break. I intend to keep going for as long as the questions are coming in. So keep the questions coming in. Keep the questions coming in. Keep the question coming in. Keep the questions coming in. Keep the questions coming in. Sending your questions. This is encouraging. Sending your questions. Keep the questions coming in. Keep the questions coming in. Sending your questions. So join us every Wednesday. Join us every Wednesday, 12 p.m. Central Standard Time. Keep the questions coming in. Keep the questions coming in. So if you can clarify the last question. Does this person mean asylum? Well, like I said, CO8 does not mean anything. CO8 is not a status. CO8 is a category under which someone can apply for employment authorization. CO8 is one of the categories under which one can apply for employment authorization. So I don't understand the question and I don't want to assume, because if I assume, I may be providing wrong answer. So can you, if the writer of the question is online listening to me, can you please clarify it? And I'm willing to answer it, but I don't want to assume. I don't want to assume. Can someone working on CO8 file for EB3? Again, I don't understand the question. There is no status. There is no status known as CO8. CO8 simply means one of the categories under which someone can apply for employment authorization. That is what CO8 means. So, we are waiting. Please clarify the question. We are waiting. This program is live every Wednesday, 12 p.m. Central Standard Time. That is 12 p.m. Dallas time. If you have questions, send in your question. Subscribe to our channel, and we'll notify you whenever we go live. There is no string attached. Okay, there's another question. Sir, what is the requirement for EB3? Can an associate degree graduate apply for it? Apparently, whoever is sending this question is just joining us. I don't want to go back to everything we have discussed. We have discussed all the requirements for EB3. EB3 simply means skilled worker. EB3 simply means a skilled worker. And for every skilled worker, you require a minimum of bachelor's degree, but there are some exceptions. If your profession requires you to have anything less than a bachelor degree in order to qualify as a skilled worker, yes, you can still be eligible. For example, if you are a nurse, you can apply for green card under EB3. And for a nurse, you are not required to have a bachelor's degree, because you can have an associate degree in nursing and still be a nurse. For as long as you pass the board exam, you will still qualify. So if your profession is such that an associate degree can qualify you as a skilled worker, yes, you can apply for EB3. You can apply for green card under EB3 if your profession qualifies anything less than a bachelor's degree as a skilled worker. And that is why I gave you the example of a nurse, a registered nurse. You don't need to have a bachelor's degree to be a nurse. You can go to a 2-year college, obtain associate degree, take your board exam, and become a registered nurse. Yes, you will still qualify under EB3. So, okay, for IT, no, for IT, well, I always say this, immigration is not a one-cap-fits-all. For IT, I'm not going to say yes or no. What I'm going to tell you is that every case is different, and it is better to seek advice from an experienced immigration attorney in order to clarify this, because someone with an IT degree that is less than a bachelor's degree may still be eligible under EB3 depending on a number of factors. Example, how long has this person been working? What certification has this person obtained? If this person presented his or her credentials to educational credential organization here in the US and his credentials are evaluated, will they make a determination that his work experience, his skills, his certifications, is all of them combined is equivalent to a bachelor's degree? This is a possibility. It's a possibility, but again, I'm not going to speculate in this person's case since I don't know a lot. There are a lot of things I don't know. So, but to answer the question, is it possible? Yes, it is one of those exceptions that is possible, depending on the peculiar situation of this person. But to simply answer, yes, it is possible, but it is not common. So keep the question coming. The person who asked the question about CO8, I hope they can clarify it. I hope they can clarify it because we have about 30 more minutes to go. And today we've been answering questions without any break. This is unprecedented. We've never done this without taking a break. Today, we are doing it straight without taking any break. So, because questions have been coming and I'm willing to continue if the questions keep coming. I see clarification, but I don't see what the clarification is. Okay, I guess someone is still typing. So keep the questions coming. We do this every Wednesday, 12 p.m. Central Standard Time. 12 p.m. Dallas time is free of charge. We don't charge any consultation. We don't charge anybody. Today, we are discussing employment-based green card. So if you have questions, keep the questions coming. Send in the question. I will be willing to answer the question. There is no string attached. The whole purpose of this is to provide information so that our people will avoid mistakes. We are trying to prevent avoidable mistakes. So tell your friends, family, keep the questions coming. This is every Wednesday, 12 p.m. Central Standard Time. Okay. The person is an asylum applicant who filed before the expiration of his I-94. So what is the question? Let me go back to the question. What is the requirement? No, I don't think that is the question. I think this is a question about CO8, if I recollect correctly. Okay, yeah, I got the question. Can someone working on CO8 file for EB3? So if I'm getting this right, the question is, can someone who is an asylum applicant who filed before the expiration of his I-94 file for EB3? Well, the answer is not a straightforward yes or no. But is it possible? Yes. But there are eligibility requirements. So the person must meet all the eligibility requirements. For example, one of them is already clarified here. The person must have submitted his or her asylum application before the expiration of the I-94. That is one of the requirements. Two, because this person has already applied for asylum, the person must show that the asylum application is not frivolous, because frivolous asylum application is a permanent bar to any immigration benefit. That is the law. Frivolous asylum application is a permanent bar to any immigration benefit. So if someone filed a frivolous asylum application, even if the person married President Biden's daughter, the person cannot get green card if immigration has made a determination that the application for asylum is frivolous. So the person will have to show that the application here is not frivolous. Thirdly, we also have to determine, has the person asylum been referred to the immigration judge? Referral to the immigration court is not a denial. So I'm not saying has the asylum been denied. All I'm asking is, has the asylum application been referred to the immigration judge? Because all these things are going to be part of the factors to consider in advising a client. And the last question I want to ask is visa available in the category that this person is applying for? In the EB category, is visa available? I know that in one of our previous episode, we discussed about this situation for someone who is a registered nurse. Yes, we are able to do that because for that person, visa was available for the person. The immigration has not made a frivolous determination relating to the pending asylum application, and that is why we were able to do that. So there are a lot of factors, there are a lot of information that this person needs to provide in order for us to properly evaluate the case. But to simply answer the question, yes, it is possible, for as long as you file your asylum before the expiration of the I-94, for as long as immigration has not made a frivolous determination regarding your pending asylum application, and visa is current for the EB3 that you are applying for. Yes, the answer is possible. And we have done that for clients in the past, and we continue to do it. Okay, the next question. I hear some noise. Can you please tell them to? The next question, his employer emailed him that he's eligible for EB3. Okay, I believe we are still talking about the same uh, asylum applicant. Yes, like I said, he may be eligible, but there are other factors that has to be considered, but he may be eligible. Okay, the next question. Then he asked the follow-up question. What will happen if I leave the workplace who filed my EB3 while the petition is still pending? Well, what I'm not sure of, because this question was transferred to me from our WhatsApp line, I'm not sure if this is still the same person who is asking question. Can you please confirm if this is the same person asking question about asylum, or if this is the question about EB3, the IT?
No, it's the asylum.
Okay. Okay. Since it's the asylum, what will happen if I leave the workplace who filed my EB3 while the petition is still pending? Again, I said this in one of my previous answer to this question. I said there are so many factors that has to be considered because I'm not sure if this person is already in removal proceedings. I'm not sure if this person's asylum application has been referred to the immigration judge. I'm not sure if this I-485 has been pending for 180 days. There are a lot of unknown attached to this question. If this person can just call in so that you clarify these things and I'll be able to give you a definitive answer. But all I'm just doing here is just to give you a general response because I don't know the specific facts of this case. So I'm giving a general response. But to give it to answer generally, yes, if the application for adjustment, that is the I-485, has been pending for not less than 180 days, yes, the applicant can change employer to a new employer. But the new employer must also be doing the same kind of job that the same kind of business that the previous employer was doing. The position must be similar to the position that the petitioning employer offered this person. If all those requirements are met, yes, he may be able to change employer without any issue. Next question, the person has been working for the workplace for a long time and it was the employer that reached out to him, is in removal proceedings. Again, I don't think I'm going to speculate further on this question. I mean, because this person is in removal proceedings, I don't know what the charges are. I don't know what the NTA is all about. I don't know what there are so many unknowns. So it's like we are just moving from one unknown to another, one unknown to another. I'm just going to advise this person to consult an experienced immigration attorney. When someone is in removal proceedings, a lot of things changes. A lot of things changes because, one, when you are in removal proceedings, it takes jurisdiction away from USCIS. When someone is in removal proceedings, USCIS will not have jurisdiction over that person. So there are a lot of factors. There are a lot of things that are going to be considered before this person can really make an informed decision on whether to change employer or not. Again, I don't know what the NTA says. Since this person's asylum has been referred to the immigration court, I don't know the basis of the referral. I don't know whether the referral notice stipulate that the application for asylum is frivolous. I don't know whether it was just a case of maybe inconsistency, or maybe the asylum officer makes a determination that the application is not credible. There are so many things that will affect this thing. But again, generally, yes, the person can change employer after the I-485 application has been pending for more than 180 days. That is the law. But the peculiar situation of this particular person is something that you want to consider when you are talking to an experienced immigration attorney. So that is what I'm going to say on this one. So please keep the questions coming. Keep the question coming. We have about 20 more minutes to go. We do this by God's grace every Wednesday, 12 p.m. Central Standard Time. So we will continue to do it 12 p.m. Central Standard Time every Wednesday. Let your family and friends know about it. Let your friends know. Join us. Subscribe to our channel so that when we go live, you'll be notified. This is free of charge. There is no string attached. We are not We are not charging anything for this. So please send in your question. Today, for the first time, we have been doing this now for 1 hour 41 minutes without taking a break, and I intend to continue going ahead for as long as the questions keep coming in. It is encouraging to have questions to be answered, but if questions are not coming in, then we will probably have to close earlier. But keep the questions coming. Okay, I think someone just sent in a question again. Will I be called for an interview once immigration is ready to make a decision on my adjustment of status based on employment? If yes, what kind of questions do they ask? Okay, this is a good question. Good question, because I've seen some what some people consider testimony. I've seen people give testimony in church because they were not invited for interview before they received their green card. Generally speaking, employment-based employment-based green card applications does not require interview. Generally speaking, that is the general rule. However, there are a couple of exceptions, but generally, 99% of the time, employment-based applications are not does not require interview. Generally, 99% of the time, employment-based applications does not require interview. And I can tell you also that the USCIS local office where interviews are conducted, they do not handle employment-based applications. So generally, interview is not part of the process for employment-based application. 99% of the time, they do not get interviewed. Having said that, there may be one or two cases where an applicant may be invited for interview. In such situation, things that can trigger interview may have to do with ineligibility. If there is a complex issue of ineligibility, the applicant may be invited for an interview. Recently, I handled a case for a client where the previous lawyer unfortunately messed up the case before they came to my office. So we filed a motion to reopen, and I wrote a very extensive brief attached to the motion to reopen, explaining why they should not penalize the client for the lawyer's error. I used a case called Matter of Lozada, and I made series of arguments, multiple arguments. I made argument that even if they want to penalize the client for the lawyer's error, the client will still be eligible based on certain exceptions to the law. I cited all those exceptions to the law and all of that. And I made all this argument. So at the end of the day, that case was scheduled for an interview. Apparently, maybe immigration wanted to hear from me apart from the written submissions. But at the end of the day, we conducted the interview, and to God's glory, that client is a permanent resident today. This was a case of 2022. It was a case of last year, late last year. The client now has the green card. The case was approved. So in such a situation, there was justification for the interview. Another thing that can trigger interview in an employment-based is crime. Maybe the client has previous conviction. the conviction may be such that immigration is not clear as to whether they should approve it or they should not. They may want to ask the client specific questions relating to the crime. So that may also bring up the issue of interview. Another scenario, health-wise, everybody applying for green card has to submit themselves for medical examination. Issues may come up in the report, in the medical examination report, that require immigration to clarify. In the past, when HIV used to be a ground of disqualification, a ground of denial, HIV is no longer a ground now. So that is important to clarify that HIV is no longer a ground for denial of green card. But it used to be. During one of those days, when HIV used to be, I remember taking a couple of clients to interview when the case was employment-based because they tested positive to HIV. Yes, in such situations, there may be interview because in that particular interview at the time, this was probably about 15 years ago, at that particular time, immigration wanted to know, one, whether the client has reported herself to, whether the client has reported herself to, what do you call this agency that deals with,
CDC?
yeah, Center for Disease Control. Yes, thank you. Center for Disease Control. Yeah. So the immigration wanted to know whether the client has reported herself to Center for Disease Control. They also wanted to know whether the client has medical insurance to be able to continue to receive treatment before they approve anything, because they already realize that the client has this problem, HIV issue. They don't want to just approve the green card and then the client will become a burden to the government. The government will now start looking for ways to take care of this HIV positive client. So they wanted to know, how are you going to take care of yourself without having recourse to public funds? So again, in such situations, interviews are conducted. But generally speaking, 99% of the time, employment-based petitions does not require interview. Before I move on to the next question, if any, another scenario that may lead to interview. Let me go back to this question about asylum, the person that has been asking question about asylum. Assuming that, this is just for the purpose of explanation, assuming that the lawyer representing this person, assuming that the lawyer and the government lawyer, the lawyer representing immigration in removal proceedings, assuming that they agree to maybe administrative closure of the case or even motion to terminate the proceedings, assuming they agree and the case is terminated, because this person has already, because this person's I-94 is already expired, because this person was already in removal proceedings, if this case is terminated to give USCIS jurisdiction to adjudicate the I-485, the officer may believe that this case is not approvable. The officer may decide to deny it. The officer may also decide to invite this applicant for interview. Let me tell you this. Recently, when I say recently, I'm talking of this year, this 2023, I had a similar case, and the case is still pending in court in removal proceedings. My client applied for asylum, of course, before coming to us. The asylum was not approved. The client was put in removal proceedings. Now, after that, the client, one way or the other, was able to get RN license and pass the board exam and got an employer to file I-140 petition for the client, and the petition was approved. Now, in court, in the removal proceedings, we had already presented the asylum as one of the client relief. Now that we have the I-140 approved, we presented it as a second form of relief. Now, the government offered termination of the case to allow USCIS to adjudicate it. Prior to that, the government initially argued that my client was not eligible for adjustment. They admitted that my client was not unlawfully present but was in unlawful status. This is one of the reasons why I keep saying that when you discuss issues like this, you need an experienced immigration attorney, because this thing is complex and only one with experience can understand it, can untangle all the different angles to it. There is a difference between unlawful status and unlawful presence. In that case, immigration argued that my client was lawfully present but in unlawful status. Now, I argued otherwise. This case was set for individual hearing. We went to court. On the day of the hearing, the government lawyers presented argument. I presented argument too. The judge was not able to proceed with the hearing. So at the end of the day, the judge instructed us to submit a written brief. So I submitted a written brief citing all the relevant laws and statutes and arguing why my client was eligible for adjustment of status. Now, I did not argue that my client was in lawful status. That was not my argument, because my client was not in lawful status. My argument was that my client was lawfully present. There's a difference between lawful status and lawful presence. At the end of the day, we went back to court. This was recently, probably a couple of weeks ago. Government offered to terminate the case and allow USCIS to adjudicate the case. I rejected the offer. I rejected the offer because if the lawyers that are representing immigration, if they are making this argument in court and the court has not ruled one way or the other, if we go back to immigration, if the case is terminated in court and we go back to immigration, what is the probability that immigration will agree with me? So I prefer that we stay in court and argue it out. I am confident of my position and I know that my client is eligible for adjustment of status. But if we don't stay in court, my client may not be able to get the green card. Because if immigration denied the application for adjustment application is a discretionary form of relief. There is no provision for appeal. This is where experience matters. When we are discussing all these things, immigration is complex and experience matters a lot. If I don't understand all of these things, I will have taken immigration's bait. I will have taken the bait. Adjustment of status, Form I-485, application to register permanent resident, it's a discretionary relief. If immigration denies it, there is no room for appeal. So, my client will be stuck. But if I present my case in court, even if the judge does not agree with me, I will have the opportunity to appeal. I'll be able to appeal to the BIA, Board of Immigration Appeal. Even if we don't win at the Board of Immigration Appeal level, I will still have another opportunity to appeal to the Federal Court of Appeal, Circuit Court, and probably up to US Supreme Court. But I will lose all those opportunities if I agree that my case go back to USCIS, because adjustment application is a discretionary form of application which we cannot appeal USCIS decision. So I hope this person, whoever sent this question, I hope you are following me. So let me go to the next question, because we have more questions coming in and we have only 4 more minutes. We have been doing this for the past 2 hours without taking a break. This is the first time we are doing this straight out without taking a break. And I can tell you, I'm enjoying it. I'm encouraged because of all the questions coming in. This is the whole purpose of doing this. Join us every Wednesday, 12 p.m. Central Standard Time. That is Dallas time. And you will be able to ask all your questions and we'll be able to answer all the questions. You can also subscribe to our channel so that whenever we go live, you will be notified. You can send in your questions ahead of time. Our number is 817-983-4499. 817-983-4499. You can call in through our direct line. You can call in through our WhatsApp number. You can chat us directly live as we are live right now. So every Wednesday, 12 p.m. Central Standard Time. Let me go to the next question. Someone has asked, when can someone apply for citizenship if they got their green card based on employment? Generally speaking, everyone that obtained green card based on employment will be eligible for citizenship 5 years from the date of the green card. The law also allowed them to apply 3 months before the 5th anniversary. However, having said that, there are a few things that can make it faster. For example, if the person, although the person obtained the green card through employment, if the person is married to a US citizen and has been married for 3 years, he can apply for citizenship in 3 years, even though he got his green card through employment. Another thing that can fasten it, if the applicant or the applicant's spouse or the applicant child joins the US military and is in active military duty, the person can get the green card today and apply for citizenship the following day. In other words, anyone who is in active military duty or whose spouse is in active military duty or whose son is in active military duty, son or daughter is in active military duty, will be eligible for citizenship after being a permanent resident for 1 day. 1 day. So I believe I've been able to answer this question. If there are no new questions, I guess we have spent the last 2 hours discussing and answering all these things. While I'm making my closing remark, if there are questions, I will be willing to answer it before I get out. But in the meantime, I encourage you to join us every Wednesday, 12 p.m. Central Standard Time. I encourage you to subscribe to our channel so that when we go live, you will be notified. I encourage you to send in your questions. You can send it ahead of time. You can send in your questions through our WhatsApp number, 817-983-4499. You can send in your questions whenever we go live. Please tell your family and friends, don't be selfish. This is free information. We are providing all these things so that our people will avoid mistakes. They will avoid making mistakes. We are not doing this for any hidden agenda. We are willing to do this every single week. The Bible says that our people perish for lack of knowledge. And because we have been doing this now, we have been practicing this immigration law or law generally for several decades. We have seen people who are making avoidable mistakes, and we continue to see them from time to time. So it became a burden for me to find additional way to educate our people so as to avoid mistakes. In the past, I've written books. I wrote American Immigration Question and Answers, hoping to educate our people. But again, I realized that a lot of our people don't read. I've attended to people who have copies of my book, and yet they kept on making the same mistakes that I warned them in the book. So I now believe that probably if we do it live like this, if we answer question one-on-one, if we have recorded question and answer on YouTube, probably people can always go back to play it whenever they have questions. They can tune in and ask us questions live whenever they have it. Probably that will prevent more mistakes. That is the sole purpose of this program. Nothing intended, no hidden agenda. So the more people are able to log in, the more people are able to be informed, the better for us, the better for me to achieve the purpose, the set goal. So don't be selfish. Tell other people about this program, and we hope to see you next time. Based on the series of questions we received today regarding R1, I am going to suggest, except we receive anything otherwise, I'm going to suggest that we are probably going to treat religious employment next week. Religious employment. We are going to be treating religious employment next week. The requirement of obtaining religious status. We'll be dealing with R1. We'll be dealing with I-360. We'll be dealing with obtaining green card through religious employment. But if other people have a better idea, if there is a topic that you want us to discuss next week, we are going to wait till the end of the day today before posting our next question. So if you have a topic that you think you want to see us discuss, please email us, send in your chat, send it to this platform, or send it to our WhatsApp number. Again, our WhatsApp number is 817-983-4499. 817-983-4499. If there are questions, topics you want us to deal with next week, send in your questions or your suggestions. Send them in today. So if you send it in, even if we don't discuss it next week, I'm sure we will consider it in our upcoming podcast. Definitely, this is viewers. It is the viewers that we are trying to satisfy. So it is whatever topic you want us to discuss that we will discuss. We are not doing this for any personal gain or any benefit or anything. So whatever topic that you want us to discuss, that is what we will discuss. So please get in touch with us. Send us messages on our WhatsApp, 817-983-4499. 817-983-4499. Send us topics you want us to discuss. And if there are no other questions, I want to thank you again for listening. Thank you for inviting your family and friends. Thank you for everything. God bless you. And because we have been doing this now, we have been practicing this immigration law or law generally for several decades. We have seen people who are making avoidable mistakes, and we continue to see them from time to time. So it became a burden for me to find additional way to educate our people so as to avoid mistakes. In the past, I've written the way you put the way you stand. Why don't you are you not the one that put the stand? Yeah, the way you why don't you
I was looking for Lawyer Shekun for help concerning my immigration status because everything was upside down. Because I couldn't believe, I was even thinking maybe I'll be sent out back to Nigeria. So on getting to know him, he explained everything to me, what I'm going to do, that he's going to do everything. So fortunately for me, everything was done from him. Dr. Lawyer Asekun is the best lawyer so far in Texas because I can introduce as many as whoever is having problem, especially when it comes to immigration. I'm going to introduce Lawyer Shekun because he is the best lawyer. So far, so good.
our goal here is to make our clients happy, especially in the area of immigration, family law, and personal injury. Okay, welcome back. Today we are discussing family-based adjustment of status. So keep your questions coming. Family-based adjustment of status. This live podcast is every Wednesday, 12 p.m. Dallas time. That is Central Standard Time. So today we are discussing family-based adjustment of status. So keep your questions coming. Next week, by God's grace, we'll be discussing employment-based adjustment of status. So today is family-based adjustment of status. So keep